This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Item number 4.
For the petitioner, my lord, I mentioned the matter yesterday.
Yes.
My lord, the matter relates to my lord. Your lordship has previously taken up this matter. My appointment was cancelled in respect of classes 9-10. My lord, I also participated in upper primary. I was merit listed. My male-female rank was 24. My female rank is 7 in both general as well as my.
Now, you participated in 2006.
Yes.
SLST, first SLST 2016, 9-10.
9-10 as well
and
as
upper primary. Just a minute. Now, thereafter, where you called for
yes.
counseling in the first round, in the previous round.
Yes, my lord.
Yes.
If your lordship, first I am showing my rank, my lord, page 67.
Yes.
My lord, serial number 61, your lordship kindly comes, the multiple ranking is there. 67.
Against which serial number?
My lord, 61.
61.
My lord, there are, kindly see all the names is
just
the petitioner, multiple ranking.
Male, female under general category 61 rank.
And no, not 61. Rank is, my lord, on the right hand side. Kindly see.
Yes, 61.
Yes, 61. Thereafter, my lord, kindly see the next. Only female general, OBC male, female, all in everywhere I have my.
Then rank. Male.
Yes.
General category 24.
Yes.
Then male, female. It is male, female 10 means.
My lord, is OBC code is the code, my lord. I am an OBC B candidate. 7.
Then what is 1?
My lord, 1 is general.
MF 161.
My lord, it's general.
General. Then F1 24 is general.
General.
Then MF 10 means.
My lord, OBC.
OBC B.
OBC B. My lord,
yes. This is your rank in connection with first SLST
upper
2016 upper primary.
My lord, next page.
So why you did not appear in the previous round of counseling?
Yes, my lord. Page 68.
Against which vacancy the petition was formed. It's not relevant that I was in 4 panels. The call which you got, the information for counseling, against which category you got it. Because in the other categories it might not have reached. So that the petition is related.
No, that commission will consider. In terms of merit, if petitioner comes within the zone of consideration,
we are dealing with lakhs of candidates.
But it is to be fed in your computer.
Each candidate,
Mr. Dr. Patro, it is to be fed in your computer and you will get the answer.
Lakhs of candidates will just casually come.
No, it's not. Dr. Patro is not a casually they are coming. They are being forced to come.
But the manner in which they are coming, firstly the delay. I will argue that I don't want to interrupt my colleague friend. Firstly, the delay. Secondly, you are not giving the proper data before the court. If you give the proper data, I can come with the proper instruction. Now I have to check all 4 categories, whether they were called. That's why I have to check the roster point. You have not mentioned anything.
Who is responsible for that, Mr. Dr. No, for cancellation of SLST 2016. So that is the reason they are coming today. Because the petitioner is pitted against all odds.
The data the petitioner has access to. The petitioner knows against which category the petitioner was called. Which panel against.
Yes, now when you were called for interview.
Next page, page 68.
Yes,
my lord, it's pure science, my lord. I am pure science. My lord, your lordship will see 1, 2, 3, 4, 5, 6, 7th, my lord, for pure science.
Yes, pure science.
My lord, up to 400, the date was also there.
So you are within 400.
400 in every category, I am within 400.
Because 61, 24, 7 rank.
And my lord, why I did not, that also I have annexed. I was blessed with a baby, my lord. Thereafter, I was serious complications. My medical report I have also.
So you have not lost the job?
Yes, I have lost the job. And thereafter, my lord, by pursuant of the order passed by the Honorable Supreme Court, since I am a candidate found not to be tainted, I have been allowed to go to school.
And you are receiving salary now?
Now I am receiving salary.
Up to 31st of December 2025.
I have the document also, my name is.
So I have already passed an order.
Yes, my lord.
Let me pass an order. But in the meantime, situation is changed.
My lord.
Today, tomorrow is the date for counseling. What can be done?
My lord, this is the order, my lord.
This is firstly, the petitioner, what he has not pointed out, though he has annexed it. He appeared in the personality test pursuant to an instrument of
Yes. Yes. I have.
His appearance is totally subject to the result of that particular petition.
My lord, I have to say something. They have accepted. It's a matter of in-service, my lord. Let me then complete, my lord. I thought it would not be taken up. Initially, in-service candidate, my lord, if that be taken up, then what is the stand I am?
So he participated, petitioner participated.
Your lordship passed an order, my lord. My lord, I am telling your lordship, initially, in-service candidates were not allowed in spite of order of court. Thereafter, again, I approached this honorable court. This honorable court, your lordship passed an order directly.
On 23rd of April.
Page 61, my lord.
Oh, previous round of litigation.
Yes, yes.
Page 61.
Kindly see. They allowed in-service candidates, every in-service candidate. But for me, I have to approach this court because they are not following their own order. Your lordship granted me liberty, and thereafter in final merit.
Just a minute. Now, whether they are permitted to participate in the personality test petition.
But the affidavits were exchanged way back in 2021. Liberty was there to mention, for the past 4 years, has my lordship taken any steps to secure, or you waited for the next?
Well, they have accepted this order finally. I have
no, but if the petitioner was permitted to participate in the personality test.
Yes.
Now, thereafter, why petitioner will be left out? Will not be permitted to participate in the counseling.
Excited that whether if I go on giving step after step without coming to a final conclusion with regard to a particular point, by way of an interim order, you appeared in the personality test. Way back 2021, panels came out in September 2024. You you did not let my lordship show that he had mentioned at least once. Liberty to mention after 6 weeks.
So let me direct that both the writ petitions to be heard together.
Yes.
But in the meantime, permit the petitioner to appear in the counseling if he comes within the zone of consideration, and if the petitioner is untainted candidate.
Yes.
Just one point, kindly. If my lord passes that order, yesterday's order, there is a slight misrecording that my lord has stated in yesterday's order that it is the stand of the commission that they will not allow absentee. But that is not what I had submitted. It is our rule. Our specific rule is that if you are absent at the time of counseling, you will not get a chance. The rule is annexed to the writ petition. It clearly states that if you are absent.
Very well. That is to be incorporated in today's order.
Yes.
Yes.
And the petitioner, my petitioner is blessed with a child. I do not want to say things very harsh. But the counseling was, when the counseling was being held, the baby was 2 months.
No, I am not entering into this issue. Because yesterday.
No, I said that I have pre-pregnancy complications, my lord. Post-pregnancy complications I have annexed. My lord, I have my medical.
Now, if court today proceeds on the premise that petitioner has lost the job, and that the order which I have passed yesterday, there is as a special case, petitioner has lost the job, let the petitioner be permitted to participate in the counseling.
Cannot be the reason for coming into this selection process. This is not a selection process which is tainted. This was also.
Why, Dr. Patro? Just a minute. Why, Dr. Patro, court will not draw inspiration from paragraph? 47 of the order of the Honorable Supreme Court
Because,
dated 3rd of April?
because of two reasons. Firstly, they were in service candidates who left their jobs and joined. These are candidates who were not in service.
Directed, if necessary, supernumerary post is to be created, are to be created.
Yes, that is for those who lost their jobs. But here, there is no supernumerary post for the person who is now going to be deprived. If I allow it,
If I am not directing the commission to dilute the merit. If in terms of merit, if he come within the zone of consideration, so there is no wrong in ousting one candidate who is in terms of merit lower than me.
If I am drawing inspiration from the Supreme Court judgment, then I have to look at the entire paragraph. What did the Supreme Court say? That if you had a job you were previously working, you can go back. When you go back, if you see that that job has been occupied by somebody else,
Then supernumerary post.
post will be created for that person.
And this is a case, Dr. Patro, where petitioner participated in both the selection processes.
Here,
And in both the selection processes, petitioners were selected. Now, petitioners were working in secondary or higher secondary sections, which in terms of emoluments and salary is a better option. So far petitioner is concerned, rightly she or he decided, candidate decided to stick to the appointment in connection with first SLST 2016, class 9, 10 or 11 and 12. Now, ultimately, because of the misdeeds of the School Service Commission, no, you have to take the responsibility. These candidates have lost the job. These candidates have lost the job. Now they are selected in another selection process, and they are coming within the zone of consideration in terms of merit. This is a better situation which is before me than the situation which was considering by the Honorable Supreme Court, and an order was passed on and the direction was, observation was made in paragraph 47 of the order dated 3rd of April. Yes.
Their recommendation that is valid for 3 months. They know this. They could have participated in the counseling.
Sure.
So, only one thing, I just conclude one last sentence, my lord.
Yes.
That is this Supreme Court, by directing supernumerary posts, they actually protected those candidates who have suffered due to these candidates coming back. But here there is no protection.
Yes, it is a better case that petitioner has lost the job, but at the same time, on being selected, since you are taking the point that they are absentee candidates, they should not be permitted. Why they remained absent, Dr. Patro? Why they remained absent? Because they are in service candidate at the material point of time, and ultimately, you are not able to produce before this court who are tainted and who are untainted. As a result, whereof Supreme Court had to set aside the entire selection process.
Anything, but they were not in service because Justice Bossack sitting in the division bench had already terminated.
Petitioner cannot be penalized at both ends. I am not saying that diluting merit you permit them. I am saying that if they come within the zone of consideration in terms of merit, permit them to participate in the counseling. Take a sympathetic stand, Dr. Patro.
Kindly record in order 2 things. One is that absentee candidates will not be permitted. That is as per the rule. That is not a policy of ours, it is the rule. And the other aspect is that the petitioner participated for this petition, I'm saying, participated pursuant to an interim order passed in a previous petition. And these 2 points we record.
Here the order, certain corrections are required. So no, it is a similar order. Basically,
only one thing, I have that list. Will I give that to your lordship?
List of?
The DI has sent that to my school where my name is appearing.
Very well. That I have recorded, and I have directed the commission that if you are coming within the zone of consideration in terms of merit, and if you are not tainted candidates, you will be permitted. To that extent, Dr. Patro made my job easy yesterday. Yes, whether the petitioner was permitted to participate in previous round of counseling. No.
Previous round of counseling, my lord, before the before 2020, before the process was
yesterday's matter, I had to deal with a situation where petitioner was invited to participate in the counseling, but she did not turn up.
My lord, in 2023, there was a counseling where I participated. Thereafter, ultimately division bench directed you do it afresh. Then again they call for counseling where I did not participate.
But you were invited.
I was invited. Page 68, my lord.
So then it's all right. You were invited.
মেমান আমি আরটিআই করে সে প্রথমেই রেখে নিয়েছি।
The interpretive sort of submitted stand is taken.
তাই
Authentic candidates have to be এইখানে না একটা যে সাবমিশনটা করলো ওটা রেকর্ড করার জন্য কমিশন দ্যাট অ্যাবসেন্টি ক্যান্ডিডেটস আর টু বি পারমিটেড টু পার্টিসিপেট are not to be permitted to participate in the ensuing counseling process, which is scheduled on 11 June 2025, which is backed by statutory provision. Which is backed, এইখানে একটা শুধু অ্যাড হচ্ছে which is backed by statutory provision লিখে রাখলে আমাকে অন্য ম্যাটারও করতে হবে।
2016 rule itself provides.
The petitioner is permitted to participate in ensuing counseling. A candidate who has already been chosen for counseling will be ousted. আর এইখানে এই ম্যাটারে একটা অ্যাডিশনাল পয়েন্ট আছে লিখে রাখো। It is contended. It is further contended on behalf of the commission that previously petitioner filed a writ petition along with other candidates, your previous petitions. A writ petition being WPA 12565 of 2021 along with other candidates. Seeking permission to participate in the personality test in connection with first SLST 2016 upper primary. Stop. While considering that writ petition, this court passed an interim order directing West Bengal Central School Service Commission to permit the writ petition to permit the petitioners, including the present petitioner, to participate in the personality test if such test is held as per the decision to be taken by the West Bengal Central School Service Commission. Stop. There was further direction to exchange affidavits in the said writ petition, and that is pending for final adjudication. Stop. It is submitted on behalf of the it is submitted on behalf of the commission that petitioner was permitted to participate in the personality test.
Page 65.
Personality test, and during pendency of that writ petition, further prayer of participation in the ensuing counseling may not be entertained. এটা 9-10 হবে, হ্যাঁ 9-10, এটা হবে না। That she has been permitted to continue as an assistant teacher till 31st December 2025 is supposed to show that the date petitioner has been identified as tentatively
করেছে কিন্তু
classes 9 and 10. This court needs to consider the issue of special functions.
স্কুলের সঙ্গে সঙ্গে কি দিয়ে যাচ্ছে?
So participant first is was selected she did not participate. It's now the time petition was working as an assistant teacher in secondary, higher secondary and secondary section on being selected.
আমরা তো ফার্স্ট পেজে চেয়েছি
For classes 9 and 10.
এখন সিম্প্যাথেটিক্যালি আপনাদের দেখা হচ্ছে। আলটিমেটলি আমরা বেঁচে যাব, কিন্তু এর ক্ষেত্রে সত্যি আলাদা। 3বার মামলা করে চাপার প্রাইমারিতে বসে আছে।
Or merit position in the list, and if the petitioner is not tainted candidate, is not verified credentials of the petitioners is the এইখানে একটা জিনিস অ্যাড করে দিলাম, এটা কিন্তু আমি দেবো না, আমি এটাকে জেরক্স কপি দিয়ে লিস্ট দ্য ম্যাটার আন্ডার দ্য হেডিং মোশন, লিস্ট দ্য ম্যাটার under the heading motion on 14 July 2025 along with the writ petition being WPA 12565 of 2021. When the consent authority of the consent consent of the petitioner is permitted to participate in the counsel, participant the petitioner and counsel. Both the writ petitions to appear on 14 July. Yes, same. Yes.
Well, I will communicate this order without this.
Yes, that is there. That leave is granted to the learned advocate for the petitioner to communicate this order to the School Service Commission without waiting for the server copy of the order. Because tomorrow is the date fixed.
Well, only one thing. Still, the Commission's office is not accessible. Can I mail it? Because this is a problem, my lord. Yesterday, and
it's now accessible.
this is not.
If my learned friend wants, they can put it in the official mail because I will commit.
My lord, deeply.
As a matter of